Jello again, this is Ben Hitchcock Cross talking to you today, and we've got another 60-page doozy from Andrea Olmanson in the Department of Corrections. I will save you, as I guess per normal now, they have copied entire pages of other decisions and just placed them wholesale in this document there for people to read, and other practices that one could criticize further. But I think we'll just let the document speak for itself here. And that's what we'll do. We're gonna focus on this contention here that are you as a peon allowed to say something that the state of Wisconsin or Andrea Olmanson doesn't agree with? I believe their answer is no, but we'll see how things go. Hold on. Here we go. This is her. She's after she's done calling me a liar and other things like that. Her basic contention is that we haven't heard any evidence of any kind. The client has been deposed once in a previous hearing, and now they're going to tell us why, based on the complaint and the deposition from the client, there's things in the complaint that absolutely cannot be true. Therefore, I am a liar. That's more or less the concept of what's going on here. So we'll see. As another example, in response to interrogatory 25, she has again pretended not to recall facts that would tend to disprove her complaint. The thing is, some of the facts that would tend to disprove any factual assertion whatsoever made in the ERD complaint that was filed in this case and that was signed by Benjamin Hitchcock Cross. It's Ben Hitchcock Cross, by the way. If you're going to spend all that time watching all these videos, you should probably get the concept that it's Ben Hitchcock Cross. Bam. On November 17th, were identified in prior briefing as complainant was previously educated on pages 49 through 51 in respondent's brief of support in its motion to compel. All right. All right. The lack of here we go. Mr. Stolar cannot feign lack of memory. She has documents in her possession to demonstrate that the complainant submitted to the ERD by her attorney is filled with falsehoods, allegations made up from whole cloth. The lack of candor and false allegations in the ERD complaint and the documentary evidence, including depositions, transcripts that refute these false allegations, were explicitly brought to the complainant's attention by the March 19, 2024 correspondence from the respondent's counsel to complainant's counsel. Okay. The following are examples of demonstrably false allegations made in the ERD complaint. Lieutenant Miller discriminates against complainant because Lieutenant Miller was worried about perceived romantic competition from complainant. Lieutenant Miller did not want competition from complainant and other younger women because Lieutenant Miller wants to be the most attractive female in her work area. Okay. These allegations were refuted by Ms. Stolar in her sworn deposition testimony. I want you to understand that they may be related or not. I guess we'll just read this here. And how do you know Alicia Miller? She was a lieutenant at DCI. In your complaint, did you make some allegations regarding Lieutenant Miller? I stated what happened with me and Lieutenant Miller. Question, in terms of the information that you put in your complaint, do you recall indicating that Lieutenant Miller discriminates against you because Lieutenant Miller was worried about perceived romantic competition from you? Objective Form Foundation, that's it. That's yours truly. I would not answer. I would not say that there was romantic competition. I would say it was because I was a woman. There was no romantic relationship involved in it. Okay. Do you see? There's a key word up here. Perceived romantic competition from complainant. Do you see that there? Perceived, okay? And because I was a woman, there was no romantic relationship involved in it, right? So she's saying we weren't actually competing about any man. That's what that says there, okay? And the word perceived, because these little words are important here because she's calling somebody a liar. So, you got to be clear about that. The ERD complaint also alleged that with respect to Lake Emily, alleged assault by Teutons. Well, I think they admit that it happened now, but I guess it's still alleged to them. Does that make them, well, we'll see. If I just got to ask you, if they say it's alleged assault here and then they admit that it happened later on in the same document, do you think that makes them liars? Is Andrea Olmanson therefore a liar? If that's the case, I guess we'll have to find out. This assault was witnessed by at least 5 Dodge Correctional Institution management, including several lieutenants and captains. Now, that's the allegation that we make in the complaint, okay? Although management witnessed the assault, they did not try to prevent it and took no action against Mr. Toutant until several months later. Okay. This conflicts with other statements made by Ms. Stolar. Consider this excerpt from Ms. Stolar's investigatory interview during the Toutant investigation. Question. So approximately when and where did this occur? At which part? When he grabbed your chest. When we were out on the ice. Okay, so that was before going to the... Yes. Do you know approximately what time? I would say 2, around 2 approximately. Okay, then who witnessed this occur? Samplowski, Steve Grabinski, which is my dad. Geez, I don't know. Dirksen was there. You know, all the white shirts were there. I don't know if they saw it. White shirts are the management that we're talking about. Okay. So do you want to see the distinction here? Here is, the assault was witnessed by at least 5 Dodge Correctional Institution management, including several lieutenants and captains. That's the allegation. Okay? Now, what this is asking her is, did she see it? This is what she's saying is, they were all standing around me, but I don't know if they saw, maybe because I was busy getting my boobs grabbed. I don't know. You know, sometimes that occupies one's attention from time to time. I'm given to understand. So, okay. We were in kind of a big group. So, I mean, really here was at least 40 or 50 people around us that could have seen it. I don't exactly who all saw it. Nate Tank was there, and I just don't know everyone's name because I kind of just keep to myself. So now, there presupposes that the only person in the universe that can give any evidence on this is Joanna Stolar, and that it can't possibly be proven. Therefore, if she's not aware of something, then it cannot be proven by any other means. That's what that's saying. The end. And it's also, I think, assuming that the only allegations you can make in a complaint are allegations that you were personally aware of. And that just isn't how fact pleading works. I'm sorry to say that. Okay. This cannot be squared with what was alleged in the ERD complaint. Since Ms. Stolar is in possession of considerable knowledge and documentary evidence demonstrating that false allegations were made in the ERD complaint, she should be required fully to respond to interrogatory number 25, omitting nothing. Okay? I don't know how their brief in response, they're citing their own argument as a fact. Okay. Remember, what attorneys say is not evidence. The documentary evidence supporting this was provided to complainant contemporaneous with that brief. In other words, complainant was spoon-fed information which would allow her to at least provide a partial answer to interrogatory 25. She was ordered to respond to it. Nonetheless, she did not. Wow. All right, sorry, that took me a second. I understand what that means. She doesn't agree with us. We are right. So therefore, not only is she lying, but she was required to change her opinion to match it with ours. That's what that says. Because we gave her evidence. See, we said that we gave her the evidence. We spoon-fed it to her. We told her what it is that we thought. All the white shirts were there. I mean, I don't know if they saw it. Okay. Now I get it. So they feel that again, it's let's clear. Let's assume that she didn't see it. Let's assume that it happened, okay? Let's assume that she didn't see who saw it, if all these white shirts saw it, and there was no other person identified by her who Ben Hitchcock Cross could have possibly talked to, just for example. Just, or that Ben Hitchcock Cross didn't do any witness interviews. Let's just assume all that to be true. Okay, no problem. Then the question is, are those two things mutually exclusive? They're just simply not. They're simply not at all the case. That because I don't see myself talking on YouTube doesn't mean that I'm not talking on YouTube. It's the bug bladder beast of trawl, I think, is what we're talking about here. If I'm wrong, let me know. But wow. Okay. We'll keep going. Here, do you want to see what not to do? This is explaining to her the law, okay? And this is saying that there's an old law that used to exist. Here's the law, okay? Cost upon a frivolous action. Love frivolity. Here's the old law, just in case you needed to spend a page on what the old law was. And now here's this case, Belich versus Simichek from 1925-year-old case. Okay, it's not. I'm not the first person to say that a 25-year-old case is. I still look to like anything after 78 to be just perfectly fine. And that's not just because it's such a great year, but it's also because it's the year after the appeals court was introduced. Appeals court by right. Okay. Sorry, here we go. Page 2, 3, 4, 5, 6, 7, 8, 9, and 10, and 11, 12, 13. And see what they're doing here is she's highlighting parts of the case as if you couldn't go read the entire case, and she couldn't synthesize the case. So that's essentially what, instead of putting it all together and giving us an understanding of what the law is, she's expecting us to go read this entire 12, 14 pages, break out just the bold parts, and come to her understanding. Okay, 14. Okay, 15. I'd say 14-ish pages. That's not what we learned, but, everybody has a different strategy. All right, here we go. The unstated positions taken by complainant and her counsel require that finder of fact suspend the use of reason, instead adopt the viewpoint of an imprudent, speculative, imaginative, and partisan person, meaning they disagree with what we did. And remember, Andrea Olbinson and Michelle Zacard both not only personally investigated all the facts of the case, but signed all the interrogatories themselves as investigators to the facts themselves. So they've now attested. That's why they're so wedded to this, because they've signed their name to the interrogatories, which have stated that that's all true. So if anything, if they're proven wrong on any of these interrogatories, they have a problem. Okay. And there's a difference between, there's 100% a difference between frivolity and the difference in the standard. I guess we're going to have to give somebody might need a notice. I guess they might. I see the issue here. I see the issue. Okay. Their positions further require that the finder of fact abandon their positions further require the finder of fact to abandon the ordinary everyday concept of cause and effect upon which a reasonable person's act standard, instead act an extraordinary, unusual, distorted, and dishonest conclusion upon which only an unreasonable person standard would act. See, she's still basically block quoting the whole thing. And it's true. Nobody wants, it's bad to do the bad thing and to suspend your disbelief. We totally agree with that. They provide, however, no legal argument to show that Bolt has been overruled, which makes sense here. And I really, really don't like these kind of statements for this reason, because I have provided no argument of any kind that Bolt has been overruled because the issue has not arisen. So that might be helpful there. I just want to say that clearly. Here's the law again. To find a petition for hearing or a claim or defense to be frivolous under sub 1, the hearing examiner must find that the party or party's attorney knew or should have known that and could not be supported by a good faith extension or modification or reversal of existing law. At no time has anybody in this case asked for an extension of the existing law or said that might in any way be necessary, helpful, or indicative of what is about to happen in this case here. We have asked for the opportunity to present our evidence without having to respond to a 60-page motion every 2 weeks, but that is not something we've had the privilege or opportunity to do. Thank you, State of Wisconsin. Complainant, thank you, Governor Tony Evers. Thank you, Jared Hoy. Thank you, Amy Petchacek. Complainant and her attorney will be unable to provide any argument, let alone a good faith argument, that viewpoint or a prudent rather than a speculative, imaginative, partisan person standard or the, cause and effect which a reasonable person as standard in Bolt, supra, should be or have been abandoned. Oh, okay. Since Bolt is still the law and has not been overruled, this is straw man nobody's made this argument. There's no good faith argument for the expense of Bolt. This entire case is frivolous, at least under. Okay. It's just, if you read everything that she was putting in there beforehand, you would have to have a demonstrable showing that we had put something in the complaint that was not only false, right, is not true as opposed to wrong, but could never have been true, and that we should have known that ahead of time. If you can prove that, then you can prove that then you get the opportunity to show that we did such a thing for an improper purpose. That's what all the case law that she cites is just showing. And now she's, I think, saying that because we're not arguing for an exchange, we haven't argued, preemptively argued for a change in the frivolity standard, that therefore our argument is frivolous. Is there did I miss a heading? Argument. The position that a fact finder must adopt a viewpoint of an imprudent, speculative, imaginative, partisan person is frivolous. Okay. I want to explain something to you. There is a thing called a administrative law hearing. At an administrative law hearing, an administrative hearing examiner hears the evidence and then renders a decision based on the evidence that they've heard, not based on the investigation by the one side. That's what's supposed to happen. Okay. So this is saying because Andrea Olmanson disagrees with what's in the complaint, and we went over 2 examples of it, therefore you would have to be insane. Oh, by the way, that's something Andrea Olmanson, remember, she advocated that I was insane for posting on YouTube. Do you remember that? I think she said psychotic. Okay. I think if you understand that better than me, be my guest and explain it to me, but that is what I'm taking away from that. The position of the complainant that a finder of fact must engage in irrational or illogical deductions, viewing facts from something other than the light of common knowledge or common experience, and then ultimately arrive at unreasonable conclusions after is frivolous. How is that any different than what she just said? Another case, okay, maybe this is another case. When analyzing facts is instructive as to the obligation of a party and her attorney. Ooh, Belich. That's not a bad case from 99. Okay, let's see how long this is. 1 page, 2 pages. Okay, 2 pages. Great. All right. The position statements in this case, I think that's their position statement. The exhibit to it, I guess Andrea can answer that question when she's a witness. We're touched. We're touched. We're going to find this button right now. We're going to find it. I'm going to use my eyes to go like this one more time. We neither want applause. Let's hope it's this one. As it could be. There. It's been a long and difficult journey, my friend, but we found ya. We found ya. They were touched. Stoller, Mr. Toutant was minding his own business when Stoller's breasts were touched. You got it. During an ice fishing tournament. That was not, by the way, parentheses, not in any way sanctioned by the Wisconsin Department of Corrections. It just so happened it was entirely filled with Wisconsin Department of Corrections staff and sent to Wisconsin Department of Corrections employees on Wisconsin Department of Corrections computers. But we don't know that because the Wisconsin Department of Corrections has refused to produce that information, and the judge has refused to respond to that motion that has been pending there, although she's responded to everything else. So that's unfortunate for us, not for maybe the Department of Corrections. Okay. Miss Stoller is unaware as to when any supervisors saw it, and that as soon as she reported to HR investigation was started, that Mr. Toutant apologized to Miss Stoller the day after the fishing event. That's what I love is when bank robbers go around and apologizing. Do you know what we frequently do? Give them a 1-day suspension. And that Mr. Stoller never again had contact with Mr. Toutant. Okay. That Miss Stoller then went out on medical leave, and that as soon as Mr. Toutant was criminally charged, he was put on leave, that Miss Stoller was assigned a light-duty position in central office, that eventually Mr. Toutant was sent to work at Waupun, a different prison, that Mr. Stoller participated in gossip as much as anyone else, and in fact solicited gossip about her, and that Miss Stoller quit her job not because of the harassment, but for other reasons, and already had another job lined up, according to her conversations via text with former employee Seipert. The position statement, the exhibits, again, this is the employer's position statement, the exhibits to it, and the record in general also demonstrate that Mr. Toutant's criminal case was dismissed, and on the same day he entered into a plea on civil disorderly conduct citation, and that after that he was suspended for a day without pay. As discussed, Supra, noteworthy and Bellick in its discussions is the financial sanctions assessed against the plaintiff's counsel. Okay. The false statement by complainant, the false statements, insults, disruption, frivolous fallings, and refusal to abide by the tribunal's orders by her counsel make a mockery of the judicial system. Okay. So, no false statements. I can't think of any insults. Frivolous filings, refusal to obey by the tribunal's orders. I disagree with all of those statements. Now, one thing, that's a disagreement. But I think there can be she may just not understand that we are not in the judicial system. We are in the administrative law system, meaning that she's just talking to one of her peers. So, Let's be clear about that. She's not talking to a judge. She's talking to another attorney who works for the governor of the state of Wisconsin. Sanctions are not only justified, but in this case necessary in order to deter not only the complainant but her attorney from future misconduct. Okay? So this case, he can't have a hearing. We can't have a deposition of Carr. And this is, if I didn't pull this out, the entire purpose of this case, I'm going to find it. You're just going to have to excuse me. All right, well, there you have it. Everything that the state of Wisconsin says is true, and everything you say is false. And if you say anything that disagrees with the state of Wisconsin, you should shut up. You should get off YouTube, and you should have to be in fear of having to pay us a bunch of money because we disagree with your statements. Once again, if we weren't clear, this is just more First Amendment violations. It may be cloth and privilege of litigation, but it may not be. So I hope, we've gone to Ms. Olmson's supervisor about these issues, and this is fully sanctioned by the Department of Corrections. There's no doubt about it. They feel that we're going after Kevin Carr by putting him on YouTube, and somehow that's a personal affront to him. Once again, these public officials being paid by public money. Kevin Carr is living off of public money even now. All of these people should be more than willing to subject themselves to democratic scrutiny. But instead, they want to use the state powers available to them to shut up democratic scrutiny against them. And that's, I submit to you, anti-American. And that I think sums it up. This brief, in a nutshell, it's anti-American.